Well, hello, everybody. It is Saturday at 3 p.m. We all know what that means. It's another edition of Zoom, Landlord Tenant Talk Radio. And my name is Dennis Block, and I'm the host here. And we were just playing a magical song, a song by the great Billy Joel, who has not written a song in the last 17 years, ladies and gentlemen, 17 years, and the has now come out with this wonderful song called "Turn the Lights Back On." So I hope you guys enjoyed it. Seems like we have a bunch of guests in our room, and I'm going to try to get to everybody's questions. But before we start, I wanted to talk about something that I have talked about before, but is incredibly important with regard to what's going to be happening here in the state of California come November. We all know there's going to be an election. And with regard to that, there's going to be something on our California ballot that I want to make sure that the word gets out, that we know what this initiative is about and why we know we have to defeat it. This initiative is called the so-called Justice for Renters. Justice for Renters, ladies and gentlemen, that's the crazy name that they put on this initiative. It's Proposition 20. You want to vote against it at all costs. This will upset our industry in a level that you will not believe. Basically, what it does is it does away with the Costa-Hawkins bill, which was initiated back in 1995. That bill had it where if you were, if it was a single family home, a townhouse, or a condominium, there could be no limitations on any rent that one could charge. It also stated that any property built after 1995, that would be from January 1st, 1996, that again, local municipalities could not impose any kind of rent limitations or rent control on those properties. So it gave landlords some power to determine what the market value of their property is, and like any other industry, be able to charge what they wanted for their housing providing services. It did also one thing else, the Costa-Hawkins bill. It did away with vacancy decontrol, or it actually a protected vacancy decontrol, which means that if you have a unit which has now been vacated by a tenant, you have the right to set the rent to whatever you like. Obviously, it would seem reasonable that you're not protecting a tenant who's already in possession. The unit is vacant, so I should be able to, at least in that situation, be able to raise the rent to market level. But this Costa-Hawkins, if it's taken back, if this Justice for Renters passes, that will basically take Costa-Hawkins off the bill, which means that local municipalities could say to you, hey, your unit is vacant. I'll let you do a 12% rent increase or a 5% rent increase. In other words, after you've suffered with a tenant who's lived there maybe half their lives and finally has vacated the unit, and your rents are really low, they're going to now impose a new limitation on what you can charge for your rents. Again, this is for a vacant unit. So again, Costa-Hawkins allows us to raise the rents to market level. It can't go above market level. You can never charge more than what something is worth. So it allows us to raise rents to market level on single family homes, condos, and townhouses. And also it allows vacancy decontrol. This Justice for Renters Act, which should be basically putting a nail in the head of all income property owners, is going to try to do away with that. Now, this act, Proposition 20, has been brought twice before by Michael Weinstein, who is the founder of the AIDS Foundation. Smart voters of California defeated this in the years 2018 and also in the year 2020. So you would think he would get the hint and get it off the ballot. So we now have to turn our attentions to making sure that you are going to vote no on Proposition 20. Make sure that you've tell every one of your friends, your relatives, your dogs, I don't care who it is. We've got to vote this one out because this would be disastrous. Even for you homeowners out there who aren't even landlords, you just own your own home and you decide, hey, you know what? I want to move out and I want to put a tenant in. You're now going to be told what you can charge rent for these properties. So this is a terrible proposition. Again, been defeated twice by the California voters, and we need to do it one more time, ladies and gentlemen. Anyway, that's my little intro for today on February 24th. We're now going to open it up to questions. Let's not forget the ground rules, and that is that this Zoom webinar is for informational purposes only. It does not substitute for getting quality legal help. Also, if you want to ask a question, please electronically raise your hand. You'll see it in your toolbar on the bottom. Just click on that, and this way I'll know to call on you. When I do call on you, I'll ask you to unmute yourself, and please keep your questions succinct and to the point, because there's a bunch of people who want to ask questions, and we want to make sure that we get to all of you guys today. And with that, I'm going to open it up to my good friend who has a wonderful first name, and his name is Dennis. Dennis, I'm going to ask you to unmute yourself.
Good morning. Yes, good afternoon. Thank you very much. I heard via KFI that there's a new law that we can no longer, on our application, ask if a incoming or prospective tenant has any pets or animals. So that's out of the question. Now my question is, okay, fine. How about, can we ask, what kind of pet or animal do you have? And therefore, if they say, well, it's just a little tiny dog, and they come in with a Rottweiler or a Doberman or a Great Dane, of course, when they're in the park with these one or three of these animals, then of course we have to do an unlawful detainer. So what is your response, please?
My response is that the law that you're referring to is not law yet. It's being proposed, and it hasn't actually become law yet. So I haven't really studied it. I did read a little news article on it where you can't even ask them if they have a pet. So what is this? I guess it's pet rights, I guess, at this point in time. But at this point, we want to, obviously, we would want to write our legislatures and say, hey, we need to be able to control our property. And sometimes it's just not proper to have a dog in our property. And we should be able to control our own fate here. So bottom line, hopefully that will not get passed. But a good question, Dennis.
Thank you.
Okay, we're going to move on to Courtney Webster. Courtney Webster, I'm going to ask you to unmute yourself.
Hi, good afternoon, Dennis. Happy Saturday.
Hey, thank you.
Thank you for being here with us today, every Saturday, really. So basically, I'm a landlord in City of Los Angeles, RSO. I have an owner-occupied duplex. I live in one unit. My inherited tenant's in another. It's a 2-bedroom. They have below market rent, and I've owned the building since April 2022. During escrow, I received a tenant estoppel that had only the wife and husband listed as month-to-month tenants in the property, and the previous owner didn't have a lease in place with the tenants. I'm an AOA member as well, and after speaking with an advisor, I was advised my lease with them had to be the same as their original one because they're RSO. So I entered into a month-to-month lease with the husband and wife listed as tenants and 4 of their adult children listed as occupants. So that's 6 people total in my 2-bedroom unit. But however, throughout 2022 and 2023, one of the adult children moved in 2 of her minor kids to the unit. The minors were not born in the unit. One of the adult children moved in a significant other. A new adult child moved in and started living in the unit with no notice, verbal or written, from my tenants. And an adult child will come every kind of month to a few weeks and move in but leave. And the husband and wife, they still live in the unit, but they also have other properties in the county, and they will kind of shuffle between them. So with March 1st approaching, because I have not served a notice yet, but with March 1st approaching, outside of the 4%, City of LA will let landlords raise the rent. Do both of the minor children not born in the unit, the adult children, and the significant other constitute a possible 30 to 40% increase?
Long question. Let's see if we can dissect it a little bit. You said that when they signed the rental agreement, that they were the husband and wife and four children. Were these four children all adults?
Yes,
Okay. Then you're saying that somewhere along the way, additional people moved in, correct?
correct.
And who are these additional people?
So one of the adult children has two minor children that moved in.
Okay, so on that one, we'll slow down. If those two minor children are there, you can raise the rent for the first child moving into the unit, and I would determine that to be the first child. You're entitled for the second child a 10% rent increase. Now, other than those two children of the child that's already permitted to be in the unit, did somebody else move in?
Yes, a significant other of one of the adult children, and then another adult child.
Okay, so as to those, you can again raise the rent an additional 10% for each of those. So we're up to 30% plus the 4%, you're up to a total of 34%. However, as to the significant other and the other adult who moved in, which would be the second and third person, then in that situation, you might also consider that you have the right to evict because these people are in violation of the rental agreement. Children moving in, minor children moving in, that I can't use as a ground to evict. But for the significant other and another adult child moving in, that could be grounds for eviction. So bottom line, Courtney, if 34% is okay with you, I think you have the right under the story you're telling me to do so.
Okay, gotcha. And then if that 34% isn't okay, call your office.
You got it. And by the way, if you're going to go above a 10% rent increase in any 1 year period, you need to serve a 90-day notice. So if you do it now, it would be for June 1st.
Okay, got it. Thank you so much, Dennis.
You take care, Courtney. Let's move on to Dev. I think I talked to you last week, Dev. I'm going to ask you to unmute yourself.
Hello, Dennis. Nice to talk to you again.
And nice
Um,
talking to you. You notice how I didn't even try to pronounce your last name.
yeah, no, you did.
I was
Yeah,
smart. I was smart this time.
yeah, no, you did good. My question was, I'm looking to convert a detached garage to ADU,
Perfect.
and two of the spots are currently they were in the previous tenants or the lease, and so do I have to notify them through like a change of tenancy, or I have to make an agreement with them to notify them, or
Okay.
do I need
Right
their permission?
now, what city are we talking about?
This is in Valley Village.
Valley Village, where my old office used to be. And with regard to this property, is it a single family home with a garage on it?
No, it's a quadplex.
Okay. So if you're going to take away someone's spot, you're going to need to serve them with a 30-day notice that they'll no longer be able to use their parking spot. And you also have to have a corresponding decrease in rent. The city has a chart that ranges from, I believe, $70 to $210 reduction that you would have to offer the tenant in their rent. And that's based on whether the difficulty of parking on street. So if there's a lot of on-street parking, then the value of their parking space would be less. If there's very little parking on the street, so they have no place else to go, then it would be on a higher side. So you have to determine which amount you're going to do, serve that notice, and then inform the tenant that pretending that their rent is $1,000, now your rent will only be $800 because I'm removing the parking spot.
Okay. And if there's room on the property to park, like an alternative, give them space, is that something I could offer them?
Yes, I think you could do that. If there's a different space, you could do that as well. If it's a less desirable space, or maybe it's not covered parking, then
Yeah, it's not covered.
I would reduce the rent a little bit then, say you can't park here, you can park there, and I'm going to give you $25 off your rent. I'm just using that as an example. If the tenant doesn't like the figure that you picked, then the tenant has the right to go to the Los Angeles Housing Department, and they'll set up a hearing where a rent advisor will determine what the amount should be for the deduction.
Got you. Okay. And then,
All right.
All right. Thanks so much.
All right, Dev. Thank you for checking in again. Let's move on. I'm doing these in order, ladies and gentlemen. I'm going to ask Victor if you'd be so kind to unmute yourself.
Thank you, Dennis. I enjoyed very much the apartment owners seminar that you conducted in Sherman Oaks last week. It was excellent, and thank you for that.
Thank you.
Today. I have a couple of questions. A couple of them are yes/no questions. One is, if I offer a tenant the ability to convert his one-year lease on a single-family home to a month-to-month lease, is that a good idea?
I don't have any problem with that, but if he's already there, then at that point, really, what's the difference at that point?
Well, we've offered him the opportunity to break the lease because he's not happy and we're not happy with him. And okay. I thought that perhaps.
Well, that's not necessarily converting it to a month to month. What you're doing is you're agreeing to do an early termination of the lease. And
yes,
and that's fine. Certainly, if you're not happy, he's not happy. This seems like a match made in heaven.
Thank you, sir. A single-family home in city of Los Angeles that is attached to two commercial storefronts. It's abutted against two commercial storefronts. You said last week that it would be subject to rent control, city rent control or statewide rent control?
It would be subject to city rent control if it's located in the city of Los Angeles. If the house was separated from the commercial buildings, then it would not be under LA rent control. But unfortunately, if they're touching, you're under LA rent control.
The rooftop of the storefronts is the deck for the house behind.
Hard to picture what you're saying, but get yourself a saw and just saw whatever you're talking about through so that there's space in between the two buildings. For example, I know like a breezeway would make that the same situation. And I've actually advised a client to, in that same situation where a breezeway connected the commercial structure to like basically a single unit. I told him, get a saw out and saw through, and he did. And then it's not subject to LA rent control.
They use the rooftop deck. The tenant in the house uses it as a patio.
If his structure is connected to the other structure, LA rent control LA Housing Department will state that it's under rent control.
Thank you.
Thank you. How do we handle it? Giving a tenant notice to perform or quit, I guess, for a single instance of a breach. For example, noise or a parking violation or unauthorized occupant in excess of 10 days per 6-month period. If we give someone...
you never serve a 3-day notice or a notice to perform or quit for noise. You can only serve it on things that you can touch, like an unauthorized occupant or parking. And you would serve that notice to perform or quit. And then after that notice expires, if the conduct still continues, they're still parking there, there's still an extra person there, then you have the right to bring forth an eviction. I'm going to move on, Victor, because you got a few questions in there. Let's move over to David. David, I'm going to ask you to unmute yourself.
Hi, Dennis. Thanks for everything. Question is, after you increase the rent for additional occupants, 6 months later, the tenant says, okay, they moved out. Do you have to bring it back to where it was? That's my number one question.
And that's a great question. And the answer is yes, you're going to have to reduce it. If you raise the rent for an additional occupant and now that occupant moves, the Los Angeles Housing Department is going to say you have to reduce it.
Okay, the next question, in case of unlawful detainer, after you serve it, the tenant answers, do you have always serve a discovery? Because that's an additional cost. Is that something that automatically...
There is not a requirement to serve discovery. That is questions on the other side that they have to answer. We also serve something called a motion to produce, where I want to see every document. Generally, where cases are not where the tenant is not represented by an attorney, or there's not, quote, a jury trial, then we normally will not ask for discovery. But there are exceptions to that. It's always a good idea to do it, but there is an expense to it. But those cases where there's an attorney involved, or where they're asking for a jury trial, in those cases, we definitely want to ask for discovery. We want to know every single aspect of why they're claiming that this unlawful detainer should not go forward. Anyway, thank you very much, David. I'm going to move on to Ferry Sarimi. Ferry Sarimi, I'm going to ask you to unmute yourself.
Hi, Dennis. I have a residential, single family residential in Mission Viejo. And then I had a slab leak, and long story short, my insurance and tenant insurance denied both of us. So she moved to the, we had the packing people to pack her stuff. So she went to she's asking me now, everything is done after 3 months. She's back to the house, but she's asking me to pay for her storage, her difference for hotel, and her gas, and all the utilities.
Okay, so the issue, and we get this question a lot, the issue is a landlord responsible for these incidental costs that occurred through no fault of the tenant? The tenant didn't do anything to create this slab leak in your house. And the answer to that is no. There is no law that states that you're responsible for her out-of-pocket expenses. The law does state that you don't have the right to charge her rent for the time that she couldn't use the property, but there's no basis under law where where you're responsible for her expenses for housing and etc. Now, it's always a good idea to bolster that in your rental agreement by having a provision that the tenant is required to have renter's insurance, and that renter's insurance should not only cover any loss to their personal property, but also cover any relocation costs if the tenant has to temporarily vacate the premises. So check your rental agreement. I know that one is in my rental agreement, and then you can kind of put that in front of your tenant and say, listen, whether your insurance company would cover you or not, you were supposed to get the proper insurance and you didn't. However, if it's not in your rental agreement, there's no legal obligation to pay for her out-of-pocket expenses.
So she had a rental agreement, but her rental insurance denied her too, because mine was denied.
Well, but again, that's not your problem. It's her problem to get the right kind of insurance to cover her losses. And if she didn't get the right kind of insurance, then again, that's not your problem.
One more question. She's 76 years old with her grandson living with her, 11 years old. She's always complaining that, she's been under so much stress because of this move and, moving out of, for living in the hotel for 3 months. Is it possible that she sue me for emotional stress or pain regarding this?
Again, we've just talked about that you have no legal obligation to pay for these items. And of course, the landlord doesn't warrant that nothing will ever go wrong with the property. I mean, things go wrong. Thing goes wrong with your car, and you have a warranty on your car. Your job is to fix it in the shortest period of time. The fact that she has, quote, stress as a result of this move, well, you know what, Ferry? Life is stressful. Things happen. But that doesn't mean that because things happen and you happen to own the house that you're responsible. So I think you're in a good position. I'm going to say thank you, and we're going to move on to Missy. Missy, I'm going to ask you to unmute yourself. Missy? Okay, Missy, we gave you a wonderful chance. Let's move on to...
Trying to do this.
Missy, you there?
Hi, can you hear me now?
Oh, I can. You hit the right button, young lady. What does it say on your cap there? 125? I can't read it. Is it Budweiser? Oh, it's
Yeah, oh,
Budweiser anniversary, 125.
it was given to me. Thank you. Thank you for this
Yes.
forum. Okay, so I went ahead and sent a notice of landlord to evict for owner occupancy. It's a triplex in RSO in LA City.
Okay.
So one of the units is already owner occupied, and eventually I just want to get out of the rental business. So I've already filed for that. The housing has provided an analyst to, I guess, give us an amount, a relocation fee amount. It hasn't come back yet. I've already given that notice to the tenant 60 days. So March 22nd, hopefully this will all be over with and I have to pay relocation fee. When the housing department comes back with an amount, can I reject that amount if I know there's some things going on with the tenant saying, I think they're trying to say, hey, you know, we got an elderly mom here, which she was never on the lease agreement. And I think they're just trying to get additional funds.
Okay, well, relocation is determined by a specific chart that the city has,
Right.
and that's determined by whether, in fact, the person who's your tenant is over 62, is handicapped, or has minor children. That would make you a qualified tenant. And if you're a qualified tenant, then it goes up to a maximum of $24,950. So the issue is whether this person is actually a tenant, this elderly person. Do you know if the elderly person is actually living there?
According to the primary tenant, she comes and goes. It's her mother, but she's not on the lease agreement.
So I think that you can object. So if the Los Angeles Housing Department comes back with that amount that indicates that they're considering her to be an actual resident, I think you can set up an appeal on that, which we have done. And we'll put it in front of an appeal hearing officer, and hopefully he'll change his mind. But right now, just keep your fingers crossed that nothing is going to happen.
Okay, and second question real quick, please. As I mentioned, it's a triplex. I want to get out of eventually in the rental business. On the third unit, can I either do a Ellis Act on that one, which is just going to take like 6 months, or a cash for keys, and I would need representation, correct? You know, for an attorney?
You always need representation, but you can't do an Ellis Act on one unit. You'd have to do them on all, which means that you're not going to be renting out the units for at least 10 years. In most situations where people do a Ellis Act, they're actually going to demolish the property and build something new. However, you can just leave it vacant for 10 years. You know, you can put your cousin or your mother in there, but technically it's not supposed to be rented out. A cash for keys is always a good way to go, assuming you can get the tenant to agree. If you're talking about the city of Los Angeles, there's a disclosure form that the tenant has to sign, saying that you've disclosed all these rules with regard to a cash for keys agreement. For example, that you have to give them 30 days to change their mind. If they don't, this disclosure agreement and your, we call it a voluntary vacate agreement, must be filed with the city. But if you can get them to agree to it, then that's the best you have.
Okay, but if they don't agree, I can do an Ellis Act on that one unit because the other two
No,
units
you
are
have to do on
owner-occupied?
all units on the property.
No, but those other two units are owner occupied already.
Then yes, then you could do it. But then again, just understand you're not going to be able to rent those units, all 3 of those units, for 10 years.
Yeah, I understand.
If that's good, then you can certainly do that, and we can assist you with that.
Yeah.
Thank you.
Thank you. Thank you so much. Appreciate it.
Appreciate you, Missy. And now we're going to move on to who's next here. Well, I don't know which one this is. I see 2 iPhones, and they're both the same color. So whoever's just listed as iPhone, I'm going to ask you, if it's an iPhone, you're going to do *6 to unmute yourself. I see 2 of them there. You got it, the one I wanted. Go ahead. Are you there?
Yes. Is that me?
That's you, young lady.
Oh, okay. Thanks. Thanks for taking my call. I have someone that's in a unpermitted unit behind where my mom was living. I had an elderly mom that allowed someone to move in the garage, and he's not doing much talking. I agreed to the relocation fee, but he doesn't really want to move. There's no mail going to that address after my mom moved because the front house is empty. I've been advised to, try to speak with him to offer him the relocation fee. But, like I said, I really believe he has nowhere to go. He's not really interested in that.
Okay, first of all, what city?
LA City.
Okay, so what you're saying is that there is a front house and there is a rear structure where he's living, and that's an illegal unit, correct?
Yes, it is. It's the garage. Yes.
And was he paying rent?
Yes, he was.
Okay, so you're in a situation where you've rented out an illegal unit in the city of Los Angeles, and that's a big no-no. So the city basically wants to punish landlords to the nth degree. Is this a person over 62 years of age?
Yes, it is.
Has he lived there longer than 3 years?
Yes. Mm-hmm.
So you just hit the jackpot whammy in the reverse way. So what you need to do is you need to, if it hasn't already been done, you need to call building and safety and turn yourself in. They will give you something called an order to comply. When you have that order to comply, then you should engage our services. But what needs to be done is that an application process has to be filed with the city. Once it's filed with the city, we would then serve on your tenant a 60-day notice to get out. And then after the service of that 60-day notice, we've got 15 days to give them the relocation. The relocation is $24,950. So that's the process. So go call, if you want to get rid of them, that's the amount you're going to have to pay. And by the way, I presume he stopped paying rent at this point?
Yeah, yeah.
Of course.
Well, I'm not accepting anything, no.
Right. Well,
no.
he doesn't have any obligation to pay rent. So go get the building and safety to come out there and turn yourself in. And then when you get that order to comply, give us a call and we'll be happy to help you.
Okay, I did fill out a form, and submit it over a week ago. I haven't heard anything back though from your company. I did submit online.
If you submit it online, then I'll tell you what, call me on Monday morning, hit my extension, which is 1001. You'll get me immediately without a wait, but you can only use that extension between 7 to 8 a.m. 7 to 8 a.m. I'm here the whole day, but if you want to get me without any wait, just call my office number. And as soon as the recording comes on, hit 1001. But again, just 7 to 8. Don't use my extension any other time.
Okay, sounds good.
Thank you, darling.
It's the same number that's on your website there?
You got it. Thank you so much. Okay, let's move on to, there's another iPhone there. Let's see, I'm going to ask that person to unmute themselves. And if you can, oh, there you go. Very good.
Hi, Dennis. I've heard you talk about mold a few times and it's not covered by insurance. What is our responsibility to know if there is mold in the units? Let's say one unit you haven't been in 5 to 10 years. How would you know if there's mold?
If you get a complaint from your tenant, then you need to have somebody go in there. First of all, view to see if you see any presence of mold, and then I would call a mold remediation company that will do some testing. And then if there is an issue, then you need to take care of it.
But if they don't notify you, you're not responsible. They can just one day show up and say, we've had mold here for years, and
well, I mean, anybody can say anything. If you're concerned with that, then you should do your own inspection. Right? Okay.
You're right. Thank you.
All right, bye-bye. Okay, Michael and Sari, let's ask you to unmute yourself. And what kind of an issue you got today, sir?
Hello, Dennis, Michael Ansari, California Golden Rock Realty and Management. How are you today?
I am fine, young sir. Everybody write that down. If you've got management issues, Michael's the man. How can I help you today?
Thank you very much. Yeah, I just have one tough question about the ex parte. What is the most damaging and downfall scenario to the landlord if someone file an ex parte during the
Okay, an ex parte is a legal term, which means that if you're involved in any lawsuit, not necessarily just an unlawful detainer lawsuit, and you would file a motion based on, it could be a million different things, but generally when you file a motion, you have to allow for 25 days before the motion can be heard. If you file an ex parte based on what they call exigent circumstances, then you can get in basically a 24-hour period. You give you're the other side notice usually before 10 a.m. on one day, and then you can go into court on an emergency basis. But again, it really depends what kind of a case you're talking about and why someone is dealing with an ex parte request. But anyway, thank you very much, Michael. We're going to move on to Harold. Harold, if you could unmute yourself, happy to answer your question.
Can you hear me, Dennis?
I do.
Man, I love these Saturdays. This is so educational. So thankful. Okay, here's a what if. It seems like the way these just cause and RSO scenarios work is that anytime you're after 6 months with a tenant, they kick in. So if I had somebody that only is there for a total of 6 months, am I excluded from any of this stuff?
Okay, so first of all, what we're talking about really is it's attributable to the city of Los Angeles.
Yeah, city of Los Angeles, Woodland Hills, owner occupied, not
right.
RSO.
So you're talking about a unit that is not under the rent stabilization ordinance, but is under what they call now the just cause ordinance, or JCO.
Yes.
All tenants now in the city of Los Angeles have a protection against eviction unless there's just cause. However, there's an exception for the JCO, the just cause ordinance, and that is if the tenant's been there less than 6 months, then you can merely just serve a 30-day notice and terminate the tenancy. So for example, if you're renting out, let's say, an apartment that was built in 1990 or 1980, so you're not under the rent stabilization ordinance, but you are under the just cause ordinance after the tenant's been there for 6 months. So do not rent, in my opinion, don't rent anything out on a fixed term lease like a 1 year or a 6 month lease. Just do month to month. And this way, if you and the tenant aren't getting along, you don't have to prove anything. All you need to do is within the first 6 months, serve them with a 30-day notice to get out. I think you, Harold, I think you hit the mute button. If you could unmute yourself, there you go.
All right. At the end of month 5, that's the time you give the 30-day notice, right at the very end of month 5. If you want to.
Well, I would do it at the beginning of month 5, not the end, because you want to make sure right. that they're out. I wouldn't get close to it. Is my position.
Hey, just quick caveat. If that's a great tenant and you want them to come back in the future, how long do they have to wait before they can come back in and start a new contract?
Well, why would you want them? Why would you? I see what you're saying. You're saying, I just want to be safe, so I'm going to knock them out and then have them come back in.
Yeah, that's a crazy idea.
Aaron, I love you, but that's crazy.
They're just going to throw me out. Okay. Thanks, man.
I am. All right. In any event, let's move on to David Dorsey. David Dorsey, how are you today, young sir?
Yes, sir. Thank you for your Zoom sessions. My property is in the city of Los Angeles, and I have a tenant, a lady who's been there for a while, more than 10 years. And her son submitted application that he wants to move in with her. And I guess we can raise 10%, but the question is that she has told me in the recent past that she has her mother owns out of state, and she has to go there, take care of things. And I'm afraid once he moves in, and she might just move to mother's house, and the guy start living there with a lower rent, which is half the market rent right now.
Right. If in fact, the law does say that you have to allow him to move in as an occupant, and you can charge 10%, but if she moves out, that would end the tenancy. And I would put that right into the contract that if you're going to allow him to move in, that if you move out, then this tenancy is over. So to protect yourself.
So, well, the contract now, I mean, we'll write.
Yeah, I would have him sign an addendum to the contract that states that if you want to move your son in, then these are the rules. The rules are, number one, you're going to give me 10% more money, and that this tenancy ends for all parties if I move out.
Yeah, the only thing is she may just come and go and say, hey, I have not moved out. Any way around that? I mean, she might not admit that she has moved out.
Well, again, if you don't see her, then that would be the issue. Okay.
Yeah. All right. But thank you, Dennis.
All right, sir. You take care. Let's go back to where we were. We were back at Adrian. Adrian, I'm going to ask you to unmute yourself. Adrian?
Hi, Dennis. Hi, Dennis. Can you hear me?
Sorry about that.
No
I'll have to
worries.
do some video editing on that one, but go ahead, Adrian.
Well, big fan. Really appreciate everything you do. It's amazing. I don't know if people realize the value, but I'm a property manager, and we inherited a property here, and we're doing a 3-day notice to quit for a tenant who hasn't paid rent. But the issue is they're living in an illegal unit in a multi-unit property. And I'm not very familiar with this aspect of it because I'm not, we don't typically handle rentals like this. So I guess the question was, this is in Sylmar.
Okay, well, we had this question already by a previous caller and or previous participant. But again, if you're renting out an illegal unit in the city of Los Angeles, that person has no obligation to pay rent. You have to go through an application process with the city, and then you have to pay that tenant relocation anywhere from $9,500 up to $24,950. In order to commence this application process, you first have to go to building and safety and get yourself cited that you're renting out an illegal unit. And then once you have that paperwork, then we can apply to the city for you.
And now, are they required to leave because it's an illegal unit, or is it at their discretion?
No, they have to leave, but we have to go through the application process. And then once we go through the application process, we then have to serve them with a 60-day notice. And then 15 days after the service of the 60-day notice, we then have to then pay them the relocation money.
Okay, I just one last really quick question. If I have a rental property in the city of San Fernando, which is unincorporated LA, is that all? Does all the RSO stuff, if it's multi-unit, is all the RSO stuff apply to that as well?
Okay, is this the city of San Fernando or is it the city of Los Angeles? Because parts of San Fernando really are Los Angeles.
I don't know. That's a really good question. It doesn't show up on RSO when I try to look it up on ZMIS.
Okay, so if it doesn't, then you're really in the city of San Fernando. And if you are in the city of San Fernando, then, and this is multi-unit, then what you are is you're under statewide rent control. That would be a lot easier in terms of an illegal unit. You'd only have to pay 1 month's rent.
Okay, that's terrific. Okay, thank you so much. I really appreciate you.
Yeah, and if you call the office, we can tell you exactly where it is.
We're going straight to you for everything. Thank you so much.
Thank you, sir. Okay, so now we're going to move on to Rod Chat. Rod Chat, please unmute yourself.
Yeah, am I unmuted?
You are perfect, and I see you wonderfully.
Excellent. Single family home in the city of Palmdale. I've rented it out 15 years, and I just want to sell it. Can I evict the tenant?
And the answer is yes. If you're in the city of Palmdale, not unincorporated Palmdale, but the city of Palmdale, we would just need to serve a 60-day notice on that tenant.
And that's it.
That's it. And then they got to get out in 60 days. Otherwise, they feel the wrath of Dennis Block.
Okay. One other quick question. I have another tenant, same single family home in Palmdale. I want to keep him, but I like giving him the low rent, but I'm worried if I get stuck in legislation changes, is there a way to like only charge him 10 months a year? And so on the books, it shows a higher rent.
No, for example, let's pretend this Justice for Renters passes, this proposition that's going to be on the November ballot. So the municipality of Palmdale could say, you know what, we want to institute rent control for single family homes, and the fact that your rent is low, well, you know what, we'll let you do a 2% rent increase. My friend, I know you want to keep rents down for this particular person. Maybe you have a relationship with them and they've been good guys, but the bottom line is this is a business and you got to treat it like a business and you got to charge market rent for your property. If you want to know what that should go for, there's a wonderful website, which I've talked about before, called Rent-O-Meter. That's R-E-N-T, the letter O-meter.com. You can put in your address of your property and how many bedrooms. It's going to show all the comparisons in your neighborhood. And if you're not in a comparable situation, you need to raise your rents to market level.
Yeah, but I'm like at $1,200 and the market's $2,500. I really
Well, do
don't
you
have the
consider
heart for
this
this
tenant your child?
No.
Okay, then raise the rent.
Okay. And last question, real quick. Can I pay for like a private consultation to ask more questions?
Absolutely. We do allow for a consultation. Usually they're 30 minutes and we can do them over the phone or a Zoom. Okay.
Okay. All
All
right.
right,
Thank you.
Rod. You take care. Good question. Jamie S. We're going to see how many we can get through here. Jamie S., if you could unmute yourself.
Hi, can you hear me, Dennis?
I do.
Hi, thank you, Dennis, for what you do for the community. I love reading your tweets. You're a strong advocate. I wish there were more of you out there. I have a question. I own a rental property in the city of Palmdale. It's a single family rental. And in the lease, I state that the tenant is responsible for the yard maintenance. However, the tenant has not upkept the yard as much as I would like. I wanted to know if I wanted to test out hiring a landscaper which I would pay for, let's say 3 to 6 months. If I start doing this service out of charity, and I later decide to not continue doing this, can this be held against me? Can this be deemed, quote unquote harassment for reducing services? Because I know in this,
No, I mean, the initial rental agreement determines what services you provided. If you want to add on an additional service for your tenant, then you can certainly take it away. Nothing prevents you from doing that. But here's the deal. If you're ever going to have a tenant where part of the rental agreement, it states that he's going to take care of the gardening, the landscaping, the pool, you are just kidding yourself. No tenant ever has ever done that in the history of landlord and tenants. So for example, let's pretend that the rent is $2,000 a month. And let's pretend that a gardener is $200 per month. And guess what? When you rent out the place, he's not supposed to touch the gardening, but you're going to charge $2,200 for this property. Never have a tenant do the gardening because they won't. They're not going to take care of your pool. They're not going to do anything, okay? So you'll be lucky if they clean the house. So never have them take care of the landscaping as a general rule. But certainly if you do it, you're not liable and you're not indebting yourself or making a contractual basis that you're now from now on responsible for the landscaping.
Okay, thank you very much.
All right, good question. We're going to move on to Janice. Janice, I'm going to ask you to unmute yourself.
Hi, Dennis. Thanks for doing this. It's really unbelievably helpful. Two questions based on one on earlier question. On the duplex, I believe it was, that had 8 people living in it. Doesn't California have maximum occupancy laws that can be enforced?
And the answer is no, they don't. They can have 20 people in a single. I mean, it's crazy, and there's no way to evict for that.
Okay. The other question is, if you let a year lease that has expired go month to month, are you required to do anything, or does it just go automatically?
Under California, and I think you're in New York, correct?
No, but well, I have my rental properties in California.
But where are you right now?
I'm in New York.
Okay, I did remember that.
Yeah.
No, it's by operation of law under the laws for the state of California in the civil code that once that lease expires, it just becomes a month-to-month tenancy by operation of law.
With any of these new proposals, if they got passed, if it's month to month, is the property manager required to send notification to the tenants updating state law?
No.
Okay.
I mean, I don't know what new laws you're referring to, but there's with regard to a tenant now coming from a 1-year lease and now it's converted to a month-to-month tenancy, there is no specific notice that needs to be.
Well, say they tried to get it, you were talking about a pet law. They tried to get a pet in after say that law passed, or Proposition 20 or anything on the.
I don't want to talk about the pet law since it's not law and I haven't really looked at it yet. But again, if you have a rental agreement that's a 1-year lease that says no pets, and then now it's a month to month, it doesn't make any difference. You're still not allowed to have a pet because that same term is there. The only thing that changes is that it's not a term lease, it's month to month.
Okay.
Anyway, thank you very much, Janice. And now we're going to move on to.
Wait, Dennis, I think you skipped me. I was next and I had an unmute, but then you didn't say my name, Leonard.
Okay.
And then an unmute button came up.
Okay, Leonard, I will talk to you. Go ahead.
Okay, sorry. Real quick question. I have an issue with a tenant living downstairs. She suffers from migraines and everything. I have a tenant upstairs that's got 2 dogs. Here we go with pets again. They got 1 dog that they said it was a therapy dog. So I said, okay, fine. Show me the letter. They showed me a therapy dog letter. Then 3 months ago, they got another dog and the dogs are running around upstairs, driving this lady nuts downstairs, constant barking. And she wants me to do something about it. And I said, I don't know what I could do. They try talking to each other and they just have conflict. And they want me to do something about it.
Leonard, the second dog is not authorized under the rental agreement. So you have the right to serve a notice to perform or quit, giving that tenant time to remove that dog. And if not, then you have the right to evict everyone from the unit.
Yeah, I don't really want to evict them though, but I thought,
you got to do something. So you've got one tenant legitimately complaining.
Yes.
And you've got to take care of that tenant. And so there has to be some sort of an adjustment with the people upstairs with one who has an unauthorized dog. And by the way, even if they have a therapy letter, all that means is that a landlord has to allow for a reasonable accommodation to have that dog. But that doesn't mean that the landlord has to have an unreasonable accommodation. So if you have a therapy dog that's barking his head off night to day, you don't have to allow that dog there, even with that therapy letter. Anyway, Leonard, I'm going to move on. Thank you. Sorry, Leonard, but we got to move on. I want to try to get to. I would think I was starting with Kimberly. So, Kimberly, if you could unmute yourself.
Yes, this is Kimberly, and I'm a client of yours. I recently got the sheriff's lockout notice from you, and I'm supposed to be at my condo February 28th for this action. Unfortunately, I'm out of state. Do I need documentation for my sister to handle that for me?
And the answer is no. Just show them the paper. We don't like talking about specific cases, but just show them the paper that we sent to you dealing with the lockout information. And anybody with that paper, the sheriff's not going to question this. Just show up. And when a lockout occurs, for that date and time, you want to make sure that you're standing on the sidewalk in front of the property with your locksmith or somebody capable of changing the locks.
Okay, then part 2 to my question, is it I need to move another sister into my unit. She would probably be income qualified for low income housing. Will HUD let me move in a relative?
You know, I just saw something on this just this last week, and somebody asked me this question, that Section 8 doesn't allow for you to have, if for a relative, a close relative, that they won't authorize that if it's a close relative. I never heard that law, but I've heard it now, so I don't think they'll do it, but you might want to check with them. Anyway, Kimberly, thank you very much. We're going to move on to Ovazine Shannon. Ovazine Shannon, if you want to unmute yourself.
Hi, Dennis. How are you?
I'm good, thank you.
Good. I spoke to you about a week ago, and you had me to go down to the Business and Consumer Affairs because they were giving me a hard time about my registry. I got it straightened, and you guys are starting a case for me on Monday with Roxana.
Right, but we don't want to talk about specific cases. That you have to call the office. If you got a general question, Ovazine, I'll be happy to answer it.
Okay, the general question: have you guys have you guys ever challenged the RSOs or the Business Consumer Affairs? Because they're giving me a runaround on something. Not the case you guys get ready to.
Okay, we have challenged them on numerous times. We get letters all the time where they're demanding that we dismiss the lawsuit, and we review what their position is, and then we basically, in most situations, tell them that we're moving forward with it. And if they have something to say about it, then let them do it legally. So we have challenged them. Anyway, thank you very much. I'm going to move on to, we still have some time here. Let's see if we can get through the last 4 here. Let's go to Q. Q, I'm going to ask you to unmute yourself.
Hi, Dennis. Thank you. I'm the landlord for a single family house in the city of Inglewood. The tenants have been there approximately 7 years, month-to-month rental agreement. I gave them notice back in October of the rental increase, which started this February, and also reminded them no dogs. As I was on the property back in October, I saw 2 dogs. So after the rains, I had a handyman go there to do some roof damage or repair. And I walked in and I asked the husband, I said, did you guys get rid of the dogs? And he told me yes. 5 minutes later, after I left, the wife calls me and said, oh, I was in the room. I heard my husband tell you we got rid of the dogs, but we're not getting rid of our dogs. They were actually in the garage. So I said, thank you for letting me know. I'll take this as your notice. You're going to be moving. So my question to you is, do I give them the 30-day notice to quit that's on your website, or do I need to do something else?
You need to do something else. I would have them have them write a statement to you that they're going to be moving on a specific date. And if they refuse to do it, then what you need to do is you need to serve on them a 3-day notice to perform or quit to get rid of the dogs. And if not, bring forth an eviction. You say you also raised the rent. Did they pay the rent increase?
Yes, they did pay the rent increase, which started this month. But she was very adamant that they're not going to get rid of their dogs, and they were planning on buying a house. And I told her, I said, hey, we appreciate your tenancy. However, you're in violation of your rental contract. It absolutely is no dogs. So this will not be a period where you could just take your time to move out. I'm just going to take this as you're giving me notice you're going to move. She says, oh, well, yeah, but there was still no date as to when they're going to move. So you're saying for me to write them a letter asking them when?
I would start with saying I need a specific date. And if you're unwilling to do this, then I would be serving on them a notice to perform or quit, giving them 3 days to get rid of the unauthorized dogs. Anyway, thank you very much. And we'll see if we can get a couple more in here. Let's go to Sharon Swain. Sharon Swain, unmute yourself, please.
All right. Hey, Dennis, this is Alex Ratliff. That was my mom. She passed away. I have a case with you. My question is about something that I heard Carla Dennis say at an AOA convention some time back. If you wanted to, and it kind of related to somebody else's question. If you have the person that they pay their rent and you give them a receipt, you ask them at that time, hey, is there anything wrong with the unit? And they say no. And what they recommend was issuing a receipt that said, here's your receipt for the month. And that you say that there's nothing wrong with the unit, and that can kind of qualify you for that month if you issue those kind of receipts to protect yourself against them saying, hey man, it's a habitability. I reported this a long time ago. It's like, hey, for 5 months I've given them a receipt, they've checked this box, they've marked it, whatever it is, and they've said there's nothing wrong with the unit. Can I do that legally?
You can, but I think a better way to do it is to have something in your rental agreement that specifically states that all repair requests must be in writing unless it's an emergency. And that way you can say, listen, if you're claiming that this problem existed, show me where you sent me something describing that issue that I refuse to take care of. So all repair, and that should be in your rental agreement, all repair requests should be in writing. When we serve a 3-day notice, and you might want to take a look, the one that's on our website at evict123.com, when we serve a 3-day notice for rent, we have a statement right on the bottom that says, hey, we don't know of anything wrong with your apartment. You haven't given us any notice, but if you have something wrong, give it to us in writing right now and we'll immediately fix it. But if we don't hear from you, we'll assume that your apartment is fine. Then when they go into court and they start talking about habitability and the reason why they didn't pay the rent, they don't look so good because, of course, they never sent the notice. Anyway, thank you very much. I'm going to do one more call, even though we're past the hour. And I'm going to go, my last caller of this week will be Eve Page. I'm going to ask you to unmute yourself.
Hi. This is my first time attending one of your Zoom meetings, and I'm wondering if we can find any previous Zoom meetings or if this one's going to be recorded that we'll be able to rewatch in the future date.
What a great question, young lady. If you go to my website, evict123.com, there's a big long button that says previous Zoom meetings, and I've got all of them there. And this one too will also be there as soon as I do a little bit of editing on it. But anyway, thank you for your question. Hopefully you are finding this to be helpful and a little bit entertaining. I want to thank everybody for joining us this week. As you know, we do this every Saturday at 3 p.m. I will be doing it next Saturday at 3 p.m., even though I've been told I have to skedaddle quickly after the telecast to a Laker game. But I still will be doing it. And but you might see me in a different location. Right here's my home office. You might be seeing in my actual office because it's actually closer to crypto.com where I'll be going for that Laker game. Anyway, once again, everybody, thank you for joining and good day. Have a great weekend and we'll see you next week.